Okay, I wanted to start a segment just on this one issue. Is it legal to secede in America? I noticed you mentioned Texas versus White. Texas versus White says you can't unilaterally secede, but it does say consent to the states. So I wanted to ask you what the threshold for consent of the states is. I think I saw you said it might mean an amendment process. I've seen some other professors say that. But I have also seen Erwin Chemerinsky, who's a top constitutional lawyer, professor of law, started 2 different law schools here in California. He said in GQ magazine that because a simple majority vote of Congress allowed California to become a state, that perhaps it's just a simple majority of Congress could be consent to the states to leave. And when we look at the language in Texas versus White, it only says consent to the states. It does not specifically say an amendment. Does it have to be a 2/3 vote for an amendment? Could it be possible it's a simple majority of Congress?
Who am I to argue with Erwin Chemerinsky, especially when he writes in GQ? I don't. So I'm an international lawyer. I don't do constitutional law. I am an American, but I'm not a specialist in American constitutional law. So I'm going to mostly punt, but I'll give you a different answer. I don't know. Is it amendment, constitutional convention? Chemerinsky says maybe. I think maybe the key word there is perhaps. Perhaps it could be just a bare vote in the Congress. Okay, that seems pretty unlikely even to my unschooled opinion. But I don't want to dwell too long on that because I'm not a constitutional scholar. In fact, what I guess I'd say about it is precisely because I'm not. I'll take this line. My main point is thinking about it from the level of international law and politics. I would not be satisfied with the idea that that's where we seek our answer exclusively. So, in my limited understanding, yeah, there's ways you could describe it, but it's also a plausible argument that at present, although the Constitution could be altered, it's probably not. There's a very plausible argument that it's not constitutional as things now stand. With all respect to Chemerinsky, most people think it would take an amendment or a convention or something like that.
True.
That means the short answer is it's unconstitutional at present under Texas v. White standards and so forth. Okay. My point, however, is something more general, and this draws on the thinking of, say, the Quebec Quebec reference court case, a fascinating case. If your viewers have a chance to look at it, it's a truly amazing piece of legal writing in general, a thoughtful discussion of deep questions. And one of the points they make there is when they look at the Canadian Constitution, of course, nothing to do with ours, but they say, look, it's not constitutional here either. But they go further and they talk about the underlying principles of their system and the broader question of what if this were to happen anyway? That is to say, outside our constitutional norms. So as you doubtless know, they arrive at the striking conclusion that although it is not, unilateral secession is not constitutional under Canada's principles, a clear desire a clear vote in favor on a clear question would compel the Federation to negotiate in good faith, which we consider a really important step. But the key point is, I think, what they also say in this reference, it's an advisory opinion, is that you also have to ask the question: what if this were to happen nonetheless? Right? That it's true that these things occur whether or not the constitutional system allows it. And then they have a very interesting discussion about the ways in which actors ought to behave so that they would eventually gain the recognition and acceptance of other states. Right? That if you did this with violence, you could expect to be resisted, even though you might succeed. But if you did it through peaceable means, then even though it's unconstitutional, you might have an expectation that other states would support you. It's a really fascinating line of argument. And the reason I raise it is the secession of California or Texas or any other part of this country constitutional? I don't think that's the critical question. To me, from my perspective, that's like a modality. That if we were to think it was right and necessary, we'd need to get the processes down, and then it would be important and useful to have a process in place. But the fact that it's not presently constitutional doesn't exactly tell us what to do. It's not the end of the discussion. You can't make this go away assuming it's a real issue, and that's a separate matter of how serious the question is now. But there are countries in which it's unconstitutional and very serious. Spain is a good example. That they just couldn't make this problem go away by declaring it to be unconstitutional. That's not politically satisfying. It's not intellectually sufficient. It's clearly an insufficient answer to just focus on the Constitution. And I think that's true here as well. We're a very constitutionally oriented society, and in many respects that's useful. But I think it distracts us from the key question here is, if it were true that California in a majority, in its millions, desire to depart, we'd either have to make that constitutional, or we'd have to think about ways that it would happen outside of the Constitution. But it would be totally unsatisfactory to argue about what it is. This is why, frankly, I'm relatively impatient with discussions about what it is the founders meant. I'm not an originalist or any other particular school in relation to this. I guess you'd call me an irrelevantist. I don't think what the founders and anyone up through the Civil War and the court in Texas v. White thought about this question should tell us what to think about it today. That if we thought it was morally and politically right to let people exit peaceably, we ought to change the Constitution to make that possible, not guided by what it currently says. As a side note, I had a separate op-ed in the LA Times on the only thing I've ever written on constitutional law on the Second Amendment, and it's very much the same line of argument. The substance is a different matter, but my point is we ought to develop a politics related to the questions of guns without reference to what we think the original or evolved meaning of the Second Amendment is. We shouldn't be guided in our politics solely by a constitutional text. And if that's true for something like guns, it is much more true on a question like secession, which is about whether or not we wish to be a political community at all. That's not a question that is easily answered by the existing constitutional order, which means it's not decisive of that question. So
Okay, I'm going to ask another question. Let me start a new